All right. Well, good morning, everybody, and thanks for joining us. This is the first of our series here. We're going to do this every Tuesday of the month. It's 30 minutes. It's quick, but it's good stuff here we're presenting. I think, first of all, I should probably just introduce so with me today, Luke Bacigalupo, one of our attorneys and COO of the company. And also is Ann Robertson, who is our business development. Anyway, welcome. This is kind of like a fixer-upper, I guess. This presentation has a solid foundation, but I can't promise there won't be a few glitches along the way. So consider this your virtual home inspection. So we're going to get started here. I think we're going to focus on. I think in all these meetings that we'll be conducting every Tuesday, every Tuesday at 11:30, every first Tuesday of the month, 11:30. Really, we're coming at this from the standpoint of what we see on our end, sort of the things that are tripping up folks and carrying all the way through closing and causing havoc. So today, I want to get focused. We're going to focus on listing agreements. And I think as we navigate, the current real estate market, it's important for us to acknowledge the growing financial distress that folks are facing, particularly as home sellers. We got rising consumer debt, we've got high mortgage rates, increasing cost of living. All those things have put a significant amount of pressure on homeowners, leading to a surge in distressed sales, pre-foreclosures, I should say, financial hardship. A lot of sellers are struggling with mounting credit card debt, personal loans and equity shortfalls, making it a difficult transition to the next home. And the financial strain is not only impacting individual homeowners, but it's also influencing market dynamics, pricing trends, buyer behavior, and all this impacts how you approach your listings, and specifically, how you guide your sellers on what needs to be disclosed to home buyers. So let's get hyper focused here on the listing agreements and the provisions relating to encumbrances, liens, title matters. So let's, first I'm going to grab my little listing agreement here. Let's first look at the GCAR listing agreement. That's Form 910, paragraph 16. Then we'll look at the NVAR listing agreement, which is Form K 1337. It's paragraph 22. I think there's a tendency, you want to get this listing agreement, you've had your listing appointment, you're working on the listing agreement. As you're going through it with your seller, there's a tendency to get focused on, what mortgages are outstanding. Let's list those. So in the GCAR form, it's paragraph 16, there are check boxes, right? And for listing outstanding mortgages that need to be paid off at closing and so forth. And I think, there's a tendency to sort of overlook the importance, I should say, of some of these other items, that are listed here. And, specifically, I'll refer to paragraph E and paragraph H. All right. So paragraph E, you're talking to your seller, no, I don't, no defaults, and not really paying attention to the language. And that's true for paragraph H too. Paragraph H, no, I don't have any judgments against me, and end of story. You check the box and so forth. Well, what we're finding, what we're seeing on our end, in fact, we are working on a matter right now, on a transaction that, I kid you not, has 31 liens. Okay. Now this is a property that if you drove by the house, you would think to yourself, well, this is a beautiful home. We're in the upper 2 million range and so forth. 31 liens. And, so really engage with your seller on these, on these particular paragraphs. Take paragraph H, for example, says there are judgments against sellers, or seller has knowledge of any matter that might result in a judgment that may potentially affect property, right? So there are a number of things that can occur. So a seller may have received a default notice. Okay. Well, that would need to be disclosed. The seller, may have received a threat of lis pendens, or even just a creditor notice, credit card debt, for example, right? Those things can turn into judgments, from the time you sign the listing agreement to closing. Okay. Now you've got a situation where the seller is exposed themselves to great liability, and you too are, facing maybe some issues here as well. So it's important that you really get the seller engaged on these. Have you received any default notices? Is there been any threat of a lis pendens, that sort of thing? So keep that in mind. And that's true in the NVAR listing form. It's a little different language, but it's still essentially the same requirements here of a seller to disclose. There again on the NVAR, paragraph H says there are no judgments against seller. Seller has no knowledge of any matter that might result in a judgment that may potentially affect the property. Again, that's really important language. Seller has no knowledge of any matter that might result in a judgment. Okay. Well, a lot of people don't understand what that means, perhaps, but what it means is what I just said, which is a creditor who's threatening can get a judgment, and that becomes a lien against the property from the time you sign the listing agreement to the time of closing, right? So it's important if a seller says, yes, okay, I received a default notice, or I received a threat of a lis pendens, or a threat of a judgment. That is a material fact. And let me just give you the definition for a material fact. Okay, that's something that has to be disclosed. And I'm going to find my little common law definition of material fact here. I'll just read it to you. A material fact in a residential real estate transaction is any fact that would significantly impact a buyer's decision to purchase the property or the price they are willing to pay. And so this falls right into that category. That's a material fact. That material fact has to be disclosed. Okay. Now the next question is, where do I, as the agent here now, where do I disclose it? Right. And that's where we'll talk more about this in our next meeting next month on addendums. But our suggestion, and we've made the suggestion to several agents, is one of two ways. You can put it right. You can create an addendum to the property disclosure disclaimer. Okay. Remember, the property disclosure disclaimer doesn't ask any of these questions really of a seller, right? You can create an addendum, put it in there, attach it. We have language we can help you with, and or put it in the agent remarks in the MLS. And it's just a one sentence thing that constitutes disclosure, that the seller has received a notice of default, or seller has received a threat of enforcement on a debt. Okay. So keep that in mind. These are things that we're seeing on our end that are causing consternation and issues. Of course, that results oftentimes when we are dealing with something like that. Now we have something like this, then we have to, are forced to go get judgment payoffs, work with that judgment creditor, and that often delays the closing. And a delay in closing, we all know, can present the seller with some liabilities. So just be very cognizant of that. I'll turn it over actually at this point to Luke. Luke's going to talk a little bit about some issues we're finding on our end regarding identifying your seller and understanding who your seller really is before you sign a listing agreement. So Luke, I'll turn it over to you.
So we'll get into kind of dealing with your seller, understanding who your seller is, and frankly, making sure that your seller does have the legal authority to sell the property. So a common pitfall we see, and frankly, it happens, I would say, on just about 25%, maybe more of entity contracts that we see on the seller side, that the person that's gone ahead and signed either the listing agreement or gone ahead and signed the contract, it doesn't actually have legal authority to go ahead and convey the property. So it's important from the onset as you're entering that listing agreement to make sure that your seller actually is seller of record or does have the ability to sell this property. So the common thing we always hear is, well, I checked the MLS, right? I checked the MLS and it said that's who the seller is. That's who owns the property. Well, the MLS, I will say, is not always right. And the reason for that is the MLS isn't pulling directly from that jurisdiction's land records. So it's going to take any public record, for example, the tax record. That's most often where it's pulled from, and we hear all the time, well, the tax record is showing who owns the property, and that's not always the case either. Really, one of the issues with the tax record is it could be just a short snippet of who's actually on title, meaning there could be multiple people on title. Only one is showing on the tax record. It could also be that the property was at one point in the name of the person showing on the tax record, but a deed has been done to either convey the property to a trust, to a corporation, to an LLC, for example. And so you're not really getting the full picture there. So that will lead to some stress for you as you move forward with your listing agreement and your contract if you have, frankly, a seller that is not actually authorized here to go ahead and sell the property legally. So we'll get into kind of the different entities here and really what you need to look out for as we go through each. So when you have a trust seller, we'll start there. So when you have a trust, you should be listing the name of the trust as the seller of your property. That should also be the entity that is on your listing agreements here. When you go ahead and actually have your seller sign, you'll want to ensure that you have one of two documents. Some trust attorneys will go ahead and put together what's called a certification of trust. So a certification of trust would be basically just a short snippet or a general snapshot, I guess, of what the trust entails. So the biggest things on that certificate of trust would be the name of the trust, and that's your seller is the name of the trust, not the trustee individually, but just the name of the trust. So it would show the name of the trust, who the trustees are, the date that the trust was formed, and then also the authority to go ahead and sell the property. So it doesn't matter really on the seller side at all if you're dealing with a revocable trust or an irrevocable trust. It's going to be the same format here. You'll need either the certification of trust, excuse me, or you'll need a full copy of the trust agreement. Either one there will work. And then obviously if the grantor of the trust here, so the person that created the trust, if they have passed, you'll also need a death certificate of the grantor, and there should be language within either the certification or the trust agreement itself that shows who the successor trustee is. So in that event, the successor trustee is going to go ahead and sign your listing agreement. What we see all the time in contracts is the trustee is just signing here on behalf of the seller as a seller, where it just says the trustee's name and not the trust. You'll want to make sure your agreements and your contracts are actually put in the name of the trust. That way there's no confusion or possible claims of misrepresentation or something from the buyer side come the time you actually go to ratify the contract. The next one that we obviously all have dealt with, I'm sure a lot here over the years, are estates. So estates can be a nightmare, obviously, but they can also be pretty easy if you have everything that you need up front. So there is a common pitfall we see when it comes to estate sellers. And oftentimes there's a will, and the person that is carrying out the will is known as the executor. So a common mishap is the executor will be the one signing the listing agreement or the contract or settlement or appear to be signing settlement documents if that's the case. but the executor may not be the person that's actually legally allowed to go ahead and sell this property. So when you go to sell property, you're going to need to have, or the decedent here will die. The heir will file probate letters, and then the court will appoint a personal representative of the estate. So the personal representative of the estate does not always need to be the same executor of the will. So for example, if someone dies, they have two kids, one child could be the executor in the will. The other child could end up being the personal representative. So we need the personal representative of the estate to be the one signing listing agreements, to be the one signing the contract as well. So what do you need really to know exactly how to proceed? So before you have anything signed, you'll need letters of administration, and those will be filed, and it'll show exactly who the personal representative is there. You'll also need the death certificate of the decedent. And then once you go to sign, similarly with the trust, it'll be John Doe as personal representative. So again, in your seller fields there, you're going to want to put the name of the estate. So it would be the estate of Jane Doe, let's say, and John is authorized as the personal representative. He will then sign John Doe, personal representative. One note on estates, and this could really cause some chaos at your settlement. If your seller is, let's say, selling a Maryland property here, and the seller had moved to DC or Virginia and had died in DC or Virginia, then a estate will be opened in either of those states. So let's say they died in DC, right? And it's a Maryland sale. The estate will be opened in DC. So you need to have an estate opened in the state of Maryland before you go ahead and sign your listing agreement or sign your contract, because what's called an ancillary estate needs to be opened in order for them to convey the Maryland property. The good news is when an estate is open, the ancillary estate does not take too long to be filed, but you're still looking somewhere around 2 weeks to maybe a month, depending on the jurisdiction, to go ahead and have the ancillary estate filed. So if it's one of those closings, which we see a lot of right now with, let's say, a cash buyer with a quick turnaround, it could throw a wrench in the plans here. So it's good to just make sure you have the letters of administration for the state that you're selling the property in prior to going ahead and moving forward with the listing agreement and the contract here. The next one I'll get into here are LLCs. So LLCs are pretty prominent in this area. We have a lot of investor buyers. So who can sign for an LLC? So you would need either the manager of the LLC, or if there's multiple members of the LLC, the documents for the LLC should set forth who is kind of the authorized signatory or the acting manager on behalf of all of the other members. There are also scenarios where you may have multiple members that need to come together to sign together. So what you'll need kind of at your listing agreement stages is you'll need the articles of organization. So those are the filing with the state that shows that the entity is registered in that state. The operating agreement is something that will lay out exactly how the LLC works. So I'll preface this with many sole member LLCs, meaning there's only one member of the LLC, do not carry an operating agreement because they're not required to. It's understood that since there's one person as a member of the LLC, that one person obviously then has the authority to go ahead and act on behalf of the LLC. There are other scenarios where you may have multiple members. So in this multiple member scenario, they should always have an operating agreement. So the operating agreement will set forth kind of the membership here, the responsibilities of the membership, and then who is authorized to sell. So you'll look to the operating agreement to see who is authorized to act on behalf of the LLC. If you have a scenario where you have a multiple member LLC where members, let's say, are strewn about the country and not everyone is able to sign or not everyone is willing to sign. What you can have done in a scenario where every member needs to go ahead and sign everything to convey is you can ask the members to execute a resolution. So the resolution will be a kind of a meeting of the members of the LLC where they will all agree on one person that's able to act on behalf of the LLC, and then they'll just go ahead and finalize the resolution. And then moving forward, you can have that person go ahead and sign your listing agreement, sign the contract, and move forward to closing, dealing just the one member. So again, with signing here for LLCs, it's as simple as John Doe, managing member, or authorized signatory if it's a resolution where they haven't been granted, let's say, a managing position with the LLC, they're just authorized to sign, then you'll go ahead and note there. In worst case, you can always default here to authorized signatory. With corporations, we don't deal with corporations a ton in this area, but they do come up every now and again. So corporations will have a set list of people who are authorized on behalf of the corporation. So you'll have officers, most typically. So your president could be CEO, CFO, secretary, etc. So these officers are authorized by the board of directors for the corporation to go ahead and act in their respective roles. So when you go to sign a listing for a corporation, or you go further with the contract, you'll need the corporate bylaws and the articles of incorporation, and that's going to show officer authority. And then most often when it comes to a corporation, you will have a board resolution that gives one officer authority over the others to go ahead and act on behalf of the corporation. In most scenarios that we see, it's going to be the president of the company or the CEO of the company. Sometimes here and there it could be a CFO or a secretary. But you'll need those documents in advance before you start moving forward, because it can really cause a nightmare scenario. And it sounds like, oh, this is kind of routine, but it does happen quite often. And obviously we see kind of a broader market picture when it comes to entities constantly. And we see these pitfalls quite often when it comes to entity sellers. I'll share a quick story here. So we had a closing last year. It was a cash buyer purchasing a property in 14 days. And the listing side had thought that the property was titled in the trust. So the grantor of the trust had passed away. They'd move forward expecting that the successor trustee go ahead and sign everything on behalf of the trust. So as it turns out, the tax record and the MLS all said that this person was authorized to sign. It turns out that the property was never put into the trust by the estate attorney, and the estate needed to be opened. Well, the grantor of the trust had also died in the state of Nevada and was trying to sell his Maryland property. So they first had to open an estate in Nevada, and then they had to open an ancillary estate in Maryland. So once it was all said and done, the cash buyer with a 14-day close waited about 3.5 months to have 2 estates opened. In that time, he had liquidated his funds out of a brokerage account to go ahead and move forward with the cash purchase of the property. And so we think constantly, how does this come back on you as the agent, or how does it come back on you as your seller? Well, since he had liquidated his funds, he filed a claim against both the real estate agent and the seller for a misrepresentation of contract, and the damages here were the lost earnings on his portfolio that he had liquidated to buy the property. So basically, had he known and had the listing side put forth correctly here that they had identified their seller, made sure that the property was held how they thought, and that the person that they were working with had legal authority to sell, this could have all been avoided. So it ended up being costly and a very time expensive process to get to settlement. So you're better safe than sorry in the beginning. Obviously, federal title will ask for these documents every time we go to selling, or we go to under contract, and we'll ask for your trust, operating agreements, anything, depending on who your seller is. But it's good for you in advance here when you sign that listing agreement to know and to be certain that your seller can go ahead and move forward from the listing agreement all the way through settlement here. And Todd, I'll kick it back to you here.
That's good stuff, Luke. Yeah, so we'll wrap it up here shortly. I just, again, want to thank everybody for joining us today, and then hope to see you the next first Tuesday of the month, again at 11:30, and we're going to discuss addendums, how to draft the appropriate addendums, but at the same time, keep yourself out of the practice of law. And so we're going to touch on that. So before we wrap it up, though, I want to invite everyone who's participating today to take a look at our real benefits program. Our real benefits program is something we've had in place for many, many years. We have several hundred participants, and I would invite you to just give it a spin. And I'll tell you just briefly about it. Probably the most compelling thing about the real benefits program is the fact that we, as a member, you're avoiding conflicts of interest that are inherent with using an affiliated title company. Because Federal Title is free from any financial ties or affiliations with brokers or agents. We underwrite title and handle your client's funds without compromising the interests of your client. And title companies as escrow agents are expected to be a neutral party, and that's exactly what we are. We remain a neutral party in the transaction, free of any influences from financial gain. So that's the first thing. Secondly, and probably as importantly, is that we provide a real credit to we call it the real credit. It's a credit against our settlement fee to your home buyers every time you refer a home buyer or seller for that matter, but a home buyer to us, which we appreciate. And so we provide a credit which is up to $750 against our settlement fee. Our overall charges compared to other companies around the area run roughly $1,000 less in total settlement charges, or what we call non-premium charges. So keep that in mind. Our service, of course, is outstanding, as you can see from our reviews, and we've been doing this for a long time, 30 plus years now. The other benefit among that program is what we call real legal consultation, where we issue a certificate to your client that gives them 2 hours of free legal consultation. It's with an outside firm. And so if they have property condition issues post-closing, or they have a contract dispute, that sort of thing, they can consult an attorney, and they get 2 hours of free legal. And that certificate is issued at the time we open up the order and presented to the client in a way that shows that it's compliments of you, the agent. And then the other thing we do is we are providing our real benefits partners a free access and free unlimited use to our Close It app. And if you've not used our proprietary Close It app, I would invite you to do so and give it a spin also. It's a very nifty product that allows you to quickly and easily prepare a buyer's cash to close amount, which is detailed. It's similar to a closing disclosure, what you'd see on a closing disclosure, with all the items, proration of taxes, and so forth. It also, of course, allows you to do a net sales sheet for your sellers. Similarly, with all the details involved with prorations of taxes, homeowners association dues, whatever it is. So it's very nifty, and I invite you to give that a try. And that's offered for free to the real benefits partners. And then lastly is, of course, we have a portal that you can access on the go, mobile or otherwise, for accessing documents for all your particular transactions, whether that's a settlement statement or a copy of the survey from one of your prior transactions. So that wraps up for the real benefits. And again, I want to thank you for coming, and I hope to see you guys again soon. And I hope this didn't come off as like some boring CE class, because that's not what we're looking to do. So anyway, we'll see you next time, and thank you.